Thank you ever so much for joining us today, everybody. I understand that it is lunchtime probably for most of the people who are at work, so I really appreciate that you're joining us today. So obviously today's webinar is about some of the updates to the most recent changes on the skilled worker visas requirements, and also a little bit of an insight into how we can prevent illegal working civil penalty. So just before we start, obviously, I just wanting to apologize first because I have a very, very bad throat at the moment. I'm recovering from a flu, so I may be coughing, sniffling. So I do apologize for that, and hopefully it wouldn't actually impact today's webinar. Um, just to start off by what we're going to do today. So we're going to have a bit of an introductions, obviously, and then we're going to talk about the skilled worker visa requirements updates published by the Home Office, and of course we will be talking about the right to work check guidance, which I think a lot of people will be quite interested in knowing, and finally, obviously, if you do get subject to any kind of illegal working information requests, how do you deal with it? And of course, if you do get penalized afterward, how would you deal with the penalties? So without further ado, today you are at a webinar hosted by Lisa's Law Solicitors, obviously by our wonderful marketing team. Just a little bit of insight to Lisa's Law if you don't know us already. Lisa's Law actually was founded in March 2012 in London. So we have our office based in London. We are an SRA regulated law firm. We have a great teams of solicitors and paralegals, legal advisors, and legal assistant who we all speak various different languages: English, Mandarin, Cantonese, Malay, Italian. So we have a wide range of solicitors. And obviously, I have to tell you a little bit about myself. My name is Peggy. I'm a qualified immigrations and commercial solicitors at Lisa's Law Solicitors, and I'm also a non-practicing barrister. So I've got my bar qualifications in 2021, but I am obviously non-practicing, but I'm practicing as a solicitor, obviously. So in terms of like the area that we are doing, I just hope that my screen is working. You can still see the screen, can't you? I don't want to use the PowerPoint option just in case, it's not showing up at on somebody else's screen. So if you're not getting the screen, please do let me know. I'm currently on page number 6 now, which is a bit of an introduction on our key practice area at Lisa's Law Solicitors. And of course, today, everybody's who joined in are wanting to find out more about the immigrations law part. But just to let you know that we don't just deal with immigration. So personally, I myself deal with corporate and commercial law as well, like legal drafting. We also have commercial and residential conveyancing. We have litigations team. We also have teams that deal with family law and private clients. If you want to find out more about it, then you could obviously, most importantly, I've been asked if you could write down, not write down, take a screenshot, but obviously if you didn't manage to get a screenshot of this will be available online as well, because our marketing team will put this webinars up on our YouTube channel. But if you haven't subscribed already, our YouTube channel, LinkedIn, Facebook, Instagram, well, it's no longer called Twitter, it's the X, but yeah, you know what I mean. And then obviously we have TikTok as well. So all these channels, you could find out a lot of free information, like today, for instance, like I'm doing a free webinars for all of you. We regularly publish updates and articles about the most recent changes to the law. Sometimes we share some interesting cases as well. We share some of our successful cases so that you are aware of what's going on in the legal sector. So I'm going to move on now, okay, because we don't have much time. The next thing that I'm wanting to say as well is, if you haven't known already, Lisa's Law not just do Lisa's Law. We also have Lisa's Tax as well, which is a accountancy firm. They do deal with a lot of accounting, provide lots of accounting and tax services. If you're wanting to find out more about it, you could ask for their contact at the end of it, but I'm not going to go into details as to what they do. But if you're wanting to find out more, take a screenshot and then check it out later on, okay? Now, without further ado, moving into the main bread and butter for today. So we're going to talk about the skilled worker visa requirements, but of course, just to start off with the skilled worker visa, we all know that why do we need skilled worker visa? So if, for instance, if you're an overseas national, well, so if you're an employer, you wanting to employ a overseas national, and that national doesn't have any leave to remain in the UK, or have a leave to remain in the UK but does not have a permissions to work, then obviously you will have to sponsor this person by giving this person a skilled worker visa. So in order to qualify for a skilled worker visa, what do you actually need? Your employer will actually need to have a skilled worker sponsor license, which we'll talk about it later. And they will also have to give you a valid certificate of sponsorship. I know it sounds a bit like they're going to give you a certificate, but it's actually not a certificate. It's almost like a online assignment of a certificate that confirm that you are being sponsored for this job, and you will need this number when you're applying for the skilled worker visa. So without this number, you're not going to be able to apply for the skilled worker visa. And of course, the job that you are applying or the job you are going to undertake is a genuine vacancy and an appropriate skill level. So for instance, if you're saying that you're going for an engineering job and then you don't have an engineering qualification, that means that you don't quite meet the skill level, and the Home Office will question as to why the employer actually thinks that you could actually take a job that require you to have a certain requirement. So for instance, if you're wanting to apply for a law job, like my job, for instance, like a solicitor, then of course you might have to have some sort of legal background in order to qualify for it. So that's what we mean by a genuine vacancy at an appropriate skill level. And obviously you will have to be paid a salary. And I know this part is the one that most confuse a lot of people as well. But basically this salary has to what we call equal to either the minimum requirement, which is now set at £38,700. But I will talk about it a bit more in details later on. And it either have to meet either the highest among the £38,700 or the going rate of the particular job code. So for instance, I think the one that I can remember on top of my head is, let's say, a business development executive. The minimum rate is 30,000, well, so the going rate is £30,960. But then obviously the minimum salary requirement is £38,700. So with this kind of situation, you will have to meet the £38,700. But for instance, if you are being employed as a director, which I remember some of the director position was about 52,000. So let's say it's a £52,000 the going rate of that particular job. Then if that was the case, you're going to have to be paid £52,000 instead of the £38,700, which is the current minimum salary requirement. And obviously the next thing you have to do is to show that you are competent in English language, at least what we call the B1 level. And with the English test related to the skilled worker visa, you will need to prove that you are able to speak, read, write, and listen. So it's 4 components. And of course, if you do have a degree from the UK or any other major speaking English countries, you may be able, well, with the UK degree, you don't have to get it extra certified, but if you have like American's university degree, maybe, and then you will have to have that verified, confirming that that degree is equivalent to a UK degree. So if you do have a degree in the UK, you are exempt from providing like obviously like an English test essentially. Then the final thing about skilled worker visa requirement is if your employer does not certify maintenance. I know it sounds like, this is quite, what do you mean by certify maintenance? Basically, when we have a certificate of sponsorship, on the certificate of sponsorship, there's an option that say certify maintenance for your employee. So if they do tick that, there's nothing you need to do afterward. But if you don't, it means that you need to prove to the Home Office, if you do come to the UK from, well, let's say you travel from outside the UK, you haven't actually been living in the UK before, you have to prove that you at least have £1,270 for at least 28 days in your account to show that you have sufficient means to sustain yourself, for the first month you come here, because obviously you don't get paid immediately after you arrive in the UK. So that is what we call the certified maintenance. Then of course there are different rules as well if there are dependents, but I'm gonna, not going to go into details in here, but if you're wanting to know more about it, you can always contact us at Lisa's Law Solicitors. Then on to the next page, we talked about the skill worker sponsor license. So do you know, just now I said that for your employer to actually sponsor you, your employer need to have a skill worker sponsor license. So they can't just say, I want to sponsor you. So if they don't have a sponsor license and they would like to sponsor you, you could actually ask your employer to get in touch with us, because we could probably help them to apply for the skilled worker sponsor license depending on their organization situation. We didn't actually go much details into it, but the three key main points when it comes to applying for skilled worker sponsor license, the Home Office would like to know that the organizations is a genuine organizations operating lawfully, so meaning that you pay your tax, you've been actually trading normally in the UK. And of course, during this period, well, during this sort of like application, you will have to show to the Home Office why do you need this sponsor license and what type of job that you are offering. And have you, or sometimes we say that, have you even tried employing this person in the UK? That's obviously is something that the current government are planning to bring back to the sort of like what we call the residence labor market test. I think some of you guys might have heard of it before, but at the moment it is still under debate, so we don't need to worry about that yet. Normally that's what we say, that try and prove that you have tried to hire, and then the best person that you hire actually is someone else who needs a sponsor license. So that's what we mean when we say that, demonstrating to the Home Office why you actually need a sponsor license. And of course, the second point is you are honest, very reliable, and that you have not engaged in any kind of, like criminal activities or any kind of behavior that is not good to the public. So when we say that, it means that an organization who has actually been subject to the illegal working penalty, which we will talk about it at a later PowerPoint slides, normally, I would say, normally, you will not stand a chance on getting onto the sponsor license anymore. So that's why it has to be, you have to be very, very careful. And also, if any of your director, so for instance, like you have a director, senior manager, or the shareholder who has previously had a license revoked, or had any kind of like criminal record, that also may raise some alarming bell for the Home Office, and they may not necessarily grant it. But you know what? We do have some successful cases before. In fact, I have helped someone else before who have had their license revoked and having to get another license, a sponsor license for a new restaurant. I have successfully helped someone else with that. So if you do have this kind of encounter with this kind of situations and you're wanting to find out a bit more, you can contact me after this webinar. And then finally, which is very, very important, you need to show to the Home Office that you are eligible, you are capable of carrying out your sponsor duties. And in terms of what we mean by capable of carrying out your sponsor duties, it means that your HR process, like for instance, how do you actually check someone else whether they are working or not? How do you have your employee report to you when they wanted to take leave? So these are the HR practice, which, nowadays when you apply for sponsor license, the Home Office has been quite tight ever since they kind of like increased the salary requirement. And of course, they also abolished the requirement of having to renew the sponsor license once every 4 years. And some of you who know or who owns a sponsor license would know that every 4 years you used to have to renew it, but now they actually changed that, so you don't have to renew your sponsor license before anymore. But that also means that the Home Office has more time trying to check people who has already got the sponsor license. They want to make sure people are carrying out the sponsor duties correctly. So any kind of old sponsor, like existing sponsor, not old sponsor, any existing sponsor or the new sponsor, you may be asked to demonstrate to the Home Office that you can carry out sponsor duties like reporting, which is important, and of course right to work checks, or how do you do your right to work checks. And that's also something that we'll talk about it at a later slides. And I also mentioned in here that in terms of for the success in getting a sponsor license, you also need to have one British national or a settled person who has to undertake the positions of level 1 user. So you don't only need to have just one level 1 user. You can have many level 1 user who are not settled person in the UK or a British national, but you need to have at least one person, because if not, you will not be able to kind of apply for the skilled worker sponsor license. That is one of the requirements set up by the Home Office. So if you want to find out more about the sponsor license, because we only touch a little bit on the sponsor license here today in this PowerPoint. So if you want to know more about it, you can get in touch with me, because I'm going to keep saying that you're going to get in touch with me, get in touch with Lisa's Law. But if you have any other questions, obviously, feel free to let us know as well. Okay. Oh, in terms of questions, I forgot that is the one most important things that I keep forgetting to tell you as well. So obviously I'm going to be going through the slides very, very quickly, and I will not be checking the Q&A functions, but I have my wonderful colleagues from marketing team who are acting as a moderator over here. They will check through the Q&A functions, and they will let me know at the end of the webinar. If you do have any other question, I will try to answer as much as possible. If I don't, I will, I'll try my best to find a way to answer all the questions. Okay, so we're moving on to the next slide about the salary requirements for skilled worker visa. This is the one that is confusing most people at the moment, and don't get me wrong, like I sometimes get very confused as well. In fact, the Home Office has been publishing, if you guys have been following as well, the Home Office has been publishing some statements of changes in immigration rules because they make a mistake. That's why we all get very confused, because the job occupations code with the salary that they have published, like the different tables, if any of you have been looking at it before, they are all very, very messy. And obviously the Home Office has said that, oh, sorry, I made a mistake. They made a mistake. So now they are publishing some new rules, which I think is set to publish around October. I think I've got them written down on my slide. I'll let you guys, I'll kind of point to you guys later on when I was on that slide. So in terms of the salary requirements, all of you would have known from the 4th of April 2024 onwards, the minimum salary for a skilled worker visa has actually been increased. So before that, we all know that it's 26,200. I still remember the times I was trying to get through as many cars as possible before the 4th of April. But yeah, so it is a huge jump, and it is a bit of a nightmare for most of the organizations as well, because now it's actually on 38,700. And for the new entrant, as you can see, is a massive jump as well. The minimum salary has been amended from the previous £20,960 to now the £30,960. So speaking of new entrant, who is this new entrant? So normally, this is where I always advise employer. If you are an employer today, any of you who are listening today who are an employer, it will be ideal for you to actually employ someone else who is switching from a student to skilled worker directly. Obviously, on the basis that, they are very good and you're really wanting to keep them in your company. Or for instance, like they've been working for you part-time and then you want to keep them in your company and you wanting to sponsor them. Then I would advise you to go ahead with that, because not only would you have saved the immigration skill charge, because a lot of people didn't know about it, if you're switching from a student visa directly to a skilled worker visa, provided that the time of his sponsorship is within 4 years, because you can only be a new entrant for 4 years, okay? So provided that it was within the 4 years time, you don't have to pay, as you as an employer don't have to pay any immigration skill charge. So that's obviously is a benefit. I mean, it's not a lot of money, but it is still can be quite, it can still be quite a lot if you're a large sponsor. For instance, I've got some clients who are large sponsor, and that obviously saved quite a lot of the money for them as well. If you are very, very certain that I wanting to sponsor this person and I'm going to be keeping them for at least 4 years. The reason why I'm saying that is because at the moment, I think for a small sponsor, the immigration skill charge is £364 per year. And for large sponsor, I think it's £1,000 per year. So imagine if you are sponsoring someone else for 4 years, you could be saving about £1,300 if you're a small sponsor. If you're a large sponsor, you're saving about £4,000, which is quite a lot of money. So so who can be considered? Student visa switching to skilled worker, new entrant. Graduate visa switching to skilled worker visa, also considered new entrant. However, though, if they have been on a graduate visa for 2 years, that 2 years calculated towards their new entrance time. So technically, if you do sponsor someone else who have finished with their skilled worker, with their graduate visa, you can only sponsor them under new entrant for another 2 years only. And the reason why I'm saying like you can sponsor them for another 2 years, that means that you can give them a lower salary. So if you, for instance, say that, oh yeah, I'm gonna give them a higher salary later on, then obviously you can straight out sponsor them for 5 years. But if not, you can only give them a certificate of sponsorship that is lasts for 2 years, and later on they will have to extend their visa again, and they will need to be paid on the standard normal rate. Okay, and of course, if you're under age of 26 at the date of your application, you will also be considered as a new entrant. There's another one that says that you'll be working towards a recognized qualifications in a UK regulated profession. This normally are mainly related to like a lot of the for instance, like doctorates or teacher qualifications, or either like professional law qualification, those kind of qualifications. So it may not necessarily be applicable to a lot of the employer. But yeah, so the main one is the first three that you will have come across quite a lot. Okay, now this table. I wouldn't have gone into very, very much details on this, because it will not make sense for me. I couldn't actually kind of tell you within the short like next 2 minutes or three. But essentially, this is actually about the salary requirements for people who has obtained the first certificate of sponsorship after the 4th of April 2024. When I say the first certificate of sponsorship, meaning that they previously have not been sponsored as a skilled worker. So like the first time they were sponsored on a skilled worker role is after the 4th of April. Then this table at the moment is going to apply to them. And you can see that I put down table 1 on here. You could take a screenshot and then you could have a quick read. If you don't understand, then get in touch with us again. So in terms of this, it pretty much like the standard applicant, I just kind of quickly go through it. With the first one, it means that you will have to be paid, obviously, the minimum salary, £38,700, the going rate of your job type under the SOC 2020, well, Standard Occupation Code 2020. That is table 1. And I know this may not make sense to anybody. No, not anybody. May not make sense to somebody, but trust me, table 1 is one of the table that was published by the Home Office under the appendix skill occupation. So they list out different table. That sort of like table 1 was mainly for some of the people, is like options A to F, and then table 2 was like so table 1's option A to E, table 2 is option F to I, but each of the options are very, very much like complicated. I wouldn't really go into details in this webinar today, but basically, as you can see, some of the people, so any things that is below the first line, like the first row, they were all considered as what we call the reduced salary, as in like when can you be paid less. So if you have a PhD level qualification, or if you're undertaking a job under the immigration salary list, which I would like to point out, some people might think like, what's the immigration salary list? So if you have known previously, we have this called shortage occupation list. So the shortage occupation list is pretty much like basically the UK couldn't find enough people in this country to do the job. So that's why they are struggling to recruit from the local local workforce, and they need to employ people from outside the UK. And a lot of these, I think I remember in the past, there were a couple of them, because I have a couple of clients who were recruiting software developers. That was one of the used to be the shortage occupation list, graphic designer, and a lot of the scientists, like the researchers, scientists. At one point there was the senior care workers as well. So care workers, and I'm sure like if you would listen to news, BBC, you would have heard like there was a shortage of skill care worker and stuff. So those were what we call the shortage occupation list, but they now don't call it the shortage occupation list. They now call the immigration salary list. And obviously with the new entrant, and if you work in the healthcare and education, because obviously we all know they always run out of nurses, doctors, care workers, teachers. That's the reason why they qualify for a much more reduced rate. So with the healthcare and educations, they pretty much have their very much separate rules. So if you got a sponsorship in the healthcare and educations, and you would like to find out how to apply for the visas and stuff, feel free to get in touch with us. We wouldn't talk into details in this, but yeah, so anything, take a screenshot. Anything you don't understand, come back to us again. Okay. So now, the next things that we're wanting to talk about is, of course, we all know that these new requirements only come out on the 4th of April. So, which means what happened to the people that has got their visa before the 4th of April 2024? So essentially, there has been a transitional provisions being put down. So as you can see, anybody else who had a valid permissions under the skilled worker road prior to the 4th of April 2024, they can actually benefit from the so-called lower salary threshold. And if you actually if you are like us, fancy having a look at the salary requirements on the occupation code list, you will notice that there is a standard column and there is also what we call the lower salary column. But obviously, if you don't if it may not make sense to some of the people, but yeah, so basically that's what I'm trying to say. Like, there was a lower salary column for skilled worker visa holder before the 4th of April who has held a skilled worker visa before the 4th of April 2024. However, though, there is a limitation to it. So you can't be on a skilled worker visa forever. And obviously we all know that if you're on a skilled worker visa, after 5 years you can apply for settlement. So technically, the Home Office has published that any kind of application for an extensions of stay or either, like settlement on the lower rate, it all had to be made before the 4th of April 2030. Because obviously, like I say, that it's always been 5 years. And they have been quite generous on that because they give another 1 more year just in case, if there is any kind of issues with the application for the extensions or any kind of delay while they were extending. So technically, any kind of application has to be made before the 4th of April 2030. So that's very important. If you're employing any skilled worker visa employing any skilled worker, you will need to make sure that they extend their stay before that, because if not, the new rules will apply to them. And of course, if they have been granted permissions as a skilled worker under the rules before the 4th of April 2024, and they has continuously held the permissions as a skilled worker since then. So they have to fit into all these criteria in order to qualify for the lower salary. And now here comes the table again. Again, not going to go into details, but as you can see from here, this is very similar to the one that I just showed you, but this is what we call the transitional provisions, and it applies to people who has applied for the obtain the first certificate of sponsorship. Actually, when we say obtain, it means that it has to be assigned before the 4th of April 2024. So if they got it, literally, I have a client who was so lucky, got assigned a certificate of sponsorship. I think it might have been on the 2nd of April 2024. In that case, he's benefiting from the lower salary. So as you can see, the salary is slightly different as well. And also you would have noticed, which I wanted to quickly brought up on this, is that the salary requirement is no longer the 26,200. So despite the fact that the Home Office say they maintained a lower salary, but they are saying that it cannot necessarily be just technically, if you work for a company, you would not expect salary to stay 26,200 every single year, isn't it? Because there is inflation. So the Home Office obviously calculated that, and they kind of expect people to have a gradual increase to their salary. So they actually have this requirement saying that if you're extending your visa or you're applying to settle, meaning that you need to make sure that your salary meets the £29,000. That's for the standard applicant. If, for instance, they were on the standard skilled worker visa road where the minimum salary requirement is 26,200, they have to meet at least this £29,000. Then, of course, all the one below were the reduced salary options. As you can see, there is like the PhD level again, and the immigration salary list, which I have mentioned just now, used to be called the shortage occupation list. So I have come across a couple of clients' inquiries quite recently about this whole there was an issue with the Home Office sort of like the salary that they were publishing. But basically, if they were to apply to extend the visa or they were applying to settle, even if they've been on, let's say, before the 4th of April, if they actually have not been increased their salary, like have not had their salary increased for like so many years, and they have been on £26,200 for so many years up to the point of now, and then obviously the rule changes in the 4th of April, and they were due to apply for the settlement by December. Then they asked me, like, Peggy, so does that mean that I have to increase my salary? And I say yes. So technically, your employer should know that if you were to kind of like apply for a settlement later on, you will have to increase your salary. If your minimum salary and you don't qualify for any reduced salary rate, then you have to increase that to £29,000. So that's quite important. And some people then ask me, does it sound weird if I just like does it sound suspicious that I just increased my salary just a couple of months before my apply for it? Because technically my employer didn't increase it since April, and I'm about to apply in about 4 months time. My salary is still on 26,200. And I say, well, this is a very difficult question. There is a chance that the Home Office may question, well, why did you not have that increase? Because technically, when you apply for the settlement, you need to show your employer need to show that they're going to employ you on this salary. They have all intention to continue to employ you after you get your settlement. It's going to be tough, but I think the Home Office may not necessarily be very, very like tight on this. You're going to have to show that, well, my employer has increased my salary because I'm performing well, and they are happy to provide me with that salary even after I get my settlement. So that is obviously one of the things, but it may vary depending on the personal circumstances. If you do have situation like this, or you are an employer employing employee that was similar to a situation that I just mentioned just now, you can come to me. Or if you're an employee, you weren't sure like how much your employer should pay you before you apply for settlement, you could also come to me as well. So I'm not going to go into more details on that. Take a screenshot. Any questions, ask me later on. Next thing. Okay. So this is pretty much, again, the link. Obviously, this is a free webinar. We're wanting to give you all the free information. If you fancy reading the appendix skill occupations, which it just took me some time to read it. Like I did read it, and it was a long day just to read all those tables, trying to refer to like different rules and stuff. If you fancy reading it, the link is over there. And now the second point is the very, very important points that I wanted to point out. So, I told you about this, the Home Office conceded that they actually made some mistake. Actually, so they publish on the 10th of September, the Statement of Changes in Immigration Rule HC217. They actually confirmed that they have made an error. They said that some of these code, but I think we did do some articles as well about this. So they make an error on some of the occupation code salary, because I remember I was talking to someone else who is a graphic designer. The salary was like 35,800 when it used to be like 23,800. So it doesn't quite make sense. But basically, they were going to publish this. So, just now I told you about sometime in October. So it will be amended on the 8th of October with the correct salary. With the correct salary requirement, because initially the first time when they published it, it was published in a statement of changes in March 2024. So don't panic if you're about to apply. Maybe wait a little bit. If you can't wait, if for instance like you wouldn't be able to wait for the 8th of October and you seems to think that your salary code is incorrect, get in touch with us ASAP, because you can't say that I don't want to apply for my settlement just because the Home Office hasn't published. So don't do that. If you do have a expiry date that is before that and you feel as though that the job code salary requirement seems to be a bit odd, get in touch with us. We can sort you out as well. Okay. Now, this is going to be the very, very interesting part as well about the right to work checks guidance. I love talking about this as well. So in terms of right to work checks, I spoke to so many of my clients, prospective clients. They keep saying to me, I did do the right to work check. And I was like, how do you do it? I checked someone else's BRP. I was like, okay, I'm sorry, you got it wrong. So I'm going to just start by saying the consequences of hiring illegal workers. So now from this point onward, just wanting to let people know that I'll be talking more about the right to work check, and obviously about hiring, about the consequences of hiring illegal workers, and potentially how you should deal with any kind of enforcement visit. That's what we normally call them. Okay. So according to the Immigration, Asylum and Nationality Act 2006, employers actually have a duty to prevent illegal working by carrying out proper right to work checks. So some people say to me, because normally when you apply for sponsor license, if you have not been doing your right to work check, I always advise my client, please don't try to please do not attempt to apply if you have not done your right to work checks properly, because nowadays the right to work checks are all done online. Home Office have a record, they could check it. I mean, some people say to me, I sometimes say to people, well, you could be lucky, they may not check, whether you have done your right to work check before. But if they do check and they found out that you didn't, they can actually do a pre-license compliance visit, so they can interview you. I have a client, well, it was an inquiry, who come to me and say to me, Peggy, I come across with these things right now. I applied for this sponsor license, but I wasn't informed that I could actually be subject to a pre-compliance visit. I've not been doing any of my right to work check. Do you think I can go and do it now? And I was very, very straightforward with them. I say, I don't think you're going to stand a chance if you have not done it before, because technically they're, they're date stamp, so you can't do it now and then say that you have done it before, because the Home Office will know about it. So even if you don't want to apply for sponsor license, you still have a duty, by the way. So this duty does not it does not sort of matter whether you are wanting to apply for a sponsor license or you don't want to apply for a sponsor license. Very important, so that you don't get hefty fines from the Home Office. We don't want any of you to get hefty fines from the Home Office, okay? Just bear in mind that employers are the one who get the fine, not the employees, by the way. So employers over here who are listening today, bear in mind, please do not try not like no not try do not hire illegal workers, because the fines at the moment are getting crazy and crazy. So the consequences, obviously, we're talking about the civil penalty. And this year, because I remember I was dealing with a couple of them before, it used to be like 10,000, 15,000, 20,000 pound max per illegal worker. Nowadays, the fine that they are handed down, because they have this new order in January 2024, the illegal working civil penalty fine has now tripled. So I have had clients who currently waiting to go to court, dealing with big hefty fines of 45,000 per illegal worker. And obviously repeated breaches, which I will talk about it later on, that's going to get up to 60,000 per illegal worker. Okay. Some people didn't know about this. It's very, very important for you to know that if you do hire someone who are illegal, and actually you actually know this person was illegal, you were knowingly offending, knowingly breaching that sort of like duty, you could face criminal consequences, and that is up to 5 years imprisonment and unlimited fine, or both. So they always like to say unlimited fine or both, which means that you can get fined and get imprisonment, and that obviously wouldn't go into your criminal record. If you're an employer that has got like, for instance, you are not a permanent resident in the UK, so, or either you have got your IRR, and then you're not initially born a British citizen, so you got an IRR, or you are on some sort of limited leave to remain, you could face an issue. Like IRR person with the indefinite leave to remain could face your settled status being revoked, which is possible. Okay, very, very rarely, but it is possible. And of course, for people who live with the limited leave to remain, you may not be granted your further extensions when you apply for it. So be very, very careful the criminal consequences of hiring illegal workers. And then other relevant consequences, the court could say that you need to stop your business. You're not allowed to trade anymore. So you close your business. The directors, which is awful, you will be disqualified. So when we say disqualified, because like I say, from a commercial corporate law point of view, when you say disqualified, this is a massive issue. You may not be becoming a directors anymore in the future. And of course, not just that as well, you may be banned. It could be 10 years, it could be 15 years, and it could actually affect your credit rating as well. So don't do that. And your business will not be permitted to sponsor any migrant workers. As I say, normally if you get the civil penalty on illegal working, almost zero chance that you could try to get a sponsor license in the future. So if you are planning to hire someone else from outside the UK, but later on, and before that, like even that was 5 years, 10 years, some people say to me, oh, Peggy, after 10 years, they may not have, they might see that I have changed. I mean, yeah, after 10 years, they may see that you have turned a new leaf, you learn your lesson, you pay your fine. Obviously, there is a chance. But normally, if it is within 1 to 5 years, I think that you stand very, very little chance of trying to get it. And of course, confiscations of the earnings that was associated with the employment of illegal workers. I'm not sure how they calculate it, but they can actually do that as well. And your premises license being revoked. So that is also something that has happened recently. If you guys have been following the news, you can have your license being revoked, and which means that you can no longer serve alcohol, serve hot food after a certain time, those kind of thing. Okay, so the consequences are scary. So what exactly is working legally? I wouldn't actually go into too much details into it. So in terms of illegal workers, I just wanted to briefly go through that. They do not have valid leave to remain in the UK. So for instance, if someone else says to you, I got a visa, and then they say to you, I'm on a tourist visa, so I'm on a visit visa. Bear in mind, visitor visa, some sort of short-term study visa, and certain type of short-term visa, they're not allowed to work. They have leave. Well, they're not called leave to remain. Those are just like an entry for them. So they technically do not have a leave to remain in the UK, or they may be considered as leave to remain in the UK, but they are not allowed to work, which is the second point that I just mentioned. Then the final point is someone who has leave to remain can work, but there is a restriction on the type of work that the person can actually do. Very, very often, like graduate visas, a skilled worker visa. So for the graduate visa, which is a lot more less restricted, but graduate visa cannot be employed as a professional sports person. Like, if anybody else watch footballs and stuff, like you can't be a professional football player. That's what essentially they mean. So obviously I know the chances of that is very, very minor, but that's what I'm trying to give you an example is what the restrictions could be. Then obviously with the skilled worker visa, that's even more important. So don't think that you can hire someone. So obviously the rule has actually relaxed since the 4th of April. Now the skilled worker visa can actually undertake supplementary work outside their normal work, and they do not have to be within the shortage occupation code. It used to be that restrictions, and now they say that is no more than 20 hours, and as long as it is a work that was within a job code that could be found on the standard occupation code. So technically, if you're hiring someone else, I mean, for instance, now if a lawyer, he or she is a skilled worker visa holder, and then he wanting to work part-time as a marketing person, then obviously that person you could hire that as well, because a marketing role is actually a valid job code. So that obviously is okay, but you have to make sure, so the person who hire him or her as the marketing person, that job cannot be more than 20 hours, and it cannot cannot overtake, or well, not overtake, but cannot affect his work or her work as the lawyer. So his primary role has still has to be the lawyer role. So that can all fall under illegal working, and I actually has been dealing with all different types of them that has happened. I actually deal with one skilled worker visa before that has got the same issue with being classified as working illegally. And again, in terms of illegal working, how they defined it, I just wanting to say that the Home Office does take that as there is a wide interpretations on that. I'll talk about it later. But technically, student visa holder, they cannot work more than 20 hours. Do not think that the Home Office don't check. They can, and if they do want it to, they will. So make sure you do not, if you do hire a student visa holder as your part-time worker, make sure they do not work more than 20 hours. That's very, very important. Skilled worker visa, if for instance, I have a clients before who got their license revoked because they sponsor someone else to work a job, but that person was not doing the job. When the Home Office did a post-compliance visit, the person was completely unaware of the job that he was supposed to undertake. So if you do sponsor someone else, you need to ensure that that person is actually doing the exact same job, the same job descriptions that you have provided to the Home Office when you give him that sponsorship. And also, don't think that working means that you are do not think that person's work for me the person's actually considered as a worker if they get paid. That is not true. So if you do give them food, accommodations, or other type of benefits in exchange of someone else's work, that can also be considered as what we call the work. And the Home Office can see that as illegal working as well, even though if you say that I didn't pay that person. Okay, so that's illegal working. Right to work checks guidance. This is the one that I just mentioned to you, and I'm pretty sure that we wouldn't named it, but I'm pretty sure that people who've been following the news would have known about this. There was a very, very famous London restaurant, which is at Baker Street. They were being found liable for hiring illegal workers on several home office rate, and it seems as though they did not even put in much effort into defending it. But apparently, the latest one took place in May 2024, and I think it was 1/3 of their workforce that was being taken away on that day was actually illegal workers. So they were being handed a fines of £470,000 after 3 visits. As you can see, 470,000 literally just on illegal working. I just wanting to say to you that the immigration enforcement officers are literally, they are doing the jobs at the moment. So really do not hire illegal workers. I have got so many inquiries about, got this and got that. And then I say that, well, most important thing is you did not do your right to work check properly. So in order to avoid hefty fines, conduct your right to work check. Okay? Now, how do we do the right to work check? So I just mentioned just now, I told you earlier on that I have got some people who come to me and say, yeah, I do the right to work check. I was doing this by checking someone else's BRP. And I say that, well, you know, BRP is not the right to work check. So as you can see, any kind of physical BRP, BRC, or FWP, the frontal work permit, they cannot be accepted as a proof because, I could, for instance, have my visas curtailed by the Home Office or revoked by the Home Office. I can still have the physical BRP permit because nobody else is policing whether I'm sending it back or not. So the only correct way of doing it is an online right to work check. The Home Office has been asking most people to convert their visa into the e-visa. Obviously, that's another way of them making sure that it's a lot more easier to regulate this whole thing. So all the e-visa holder, if any of your employee hadn't done it, or employer, you have a different type of visa, you haven't done it, please tell them they need to do it. And the sticker, some of the people who have the IRR stickers on their passport, I just want to let you know that that will soon not be valid. So obviously, some country will still allow you to exit the country, but when you enter the UK, at some point, the Home Office will tell their border officers they're no longer allowed to do that. So if you have a sticker on your passport, you need to change it to e-visa. And employer, bear in mind, even if someone says ILR, they have a BRP, you can't just say that you've done your check by checking the BRP. You still need to do the share code. And a sticker on the a sticker on the passport is not a valid right to work check. I just wanting to let you know. So if any of your employees have a sticker on their passport, they need to change it now. They need to apply for the no time limit first, and they need to get their e-visa sorted later on. And in terms of how to do the online right to work check, they're all over there. Most important thing is you need to get the share code from your employee. You need to get their date of birth. And once you got the share code, the link, which is right there, obviously, like I say, we provide you all the information over here. The link's right there. You need to go and check the share code and the date of birth, and you will see a picture. You then have to make sure the picture was exactly the same person. The Home Office will not accept any reason saying that you can't recognize the face or you simply do not know. So you have to try your best to confirm this two persons, the pictures, and the person who come to your company for the job is exactly the same person. And once you've done that, nowadays the Home Office has those options where you can export as a PDF. Actually, you can actually just print out the page. You need to record it. You need to write down signed and keep this evidence for at least 2 years. That's a legal requirement, by the way. So not just me saying that you need to keep it for 2 years. There's legal requirements. And for the British citizens or Irish citizens, you can actually request to conduct a manual right to work check by checking the person's passport, like it's either British passport, Irish passport. This identity service provider is actually like a third-party provider where you check someone else online ID. There's a risk with online ID as well. So I would recommend if you do that, you should get the actual passport of the person, ask them to come into your workplace as well and do it manually. Then, of course, once you've done that, you need to record the date, that you checked it, you need to sort of write down, like, scribble, right to work check, done on this date. And then on the copy of the passport, just sign your picture, sign your name as well, and keep that same records for 2 years, just like the online right to work check. So the online right to work check, you've done it, you still have to print it out. Make sure you print it out. It's not just you've done it and then you're done. Okay. Then this one is the interesting part. So some people say to me, they don't have a share code. So technically, this shouldn't really be a problem anymore when, all the peoples are changing into the share code option. Because in the past, it was only a lot of people with the EU settled status have a share code to provide. But nowadays, more people has got share code to provide, including students, graduate visa holder as well. But so for instance, if someone else haven't got a share code, so for instance, like when any of your employee, their visas expired, they don't have a share code to provide anymore, or they don't have their visa to provide, they have submitted an in-time application, but the Home Office haven't made the decisions. So in situation like this, you need to use what we call the employer checking service. I always refer it to ECS. It's an online form, again, provided you with the link. You need to go into the employer checking service link. You need to input all the details. And then once you submit, you'll receive a verification notice from the Home Office. They're usually very quick. I think a lot of them took about 1 to 2 working days to come back on this. Usually you get a positive verification notice, which will be green, or a negative verification notice. If you do get a negative verification notice, you cannot employ this person. And I just wanting to say that every of these checked, you should do it before this person actually start working for you. Trust me, I have people actually who was being found being fined as an illegal worker just because that person was on the very same day come into the office to try out for work, and he actually didn't have a right to work. So if you have someone else who's going to come in to work for you, no matter they're trying, for like a couple of hours or something, you still need to make sure this person actually have the right to work before you decided to let them try for work or employ them at all. So do that before having them in. So yeah, the employer checking service, like I say, you for people who does not have a share code that can provide, or if they have a pending appeal or pending application, pending review of the Home Office, usually if you do that, the Home Office will normally refer back to you saying that, oh, this person can work up to 6 months, and then obviously 6 months later, when it's expired, you need to recheck again. So the right to work check, I just wanting to let you know, good practice is once every 6 months you should do it. So not just because you never know, some people may have, some of your employee may got into some trouble and then got their visas revoked. They didn't tell you about it, and then you can't blame the employee for not telling you. Obviously, employees should tell you, but the Home Office wouldn't see that. The Home Office would just say that you didn't do your job, you didn't do your right to work check. So very important, do that. So finally, we are on our final sections, which is about how do we deal with the penalties for employing illegal workers. I know we're going to go over the time a little bit. I try to rush as much as possible. I do apologize for that if you're thinking that I'm speaking so quickly at the moment. So what will happen if the Home Office actually thinks that you are employing illegal worker? So you do, I have to say that people can report you as well. So somebody else can make a little tips to the Home Office saying that I'm suspecting this person was employing illegal workers. If they receive a couple of some of these like so-called tips, they will start conducting investigations, and they could do unannounced visits and raids, which happens the most, which is what we call the immigration enforcement visit. And they will just come in with the big cars, and then they will suddenly just go into the premises, and then they will stop everybody else from doing anything. So they can do that. They can interview the employees and the senior management team separately, and then can also ask to check your records as to how you do your right to work checks. And I have to say, most people that I come across that has been given an illegal working penalties have not done their right to work checks properly. So please do your right to work checks properly. Then in terms of how and what you need to do when you are being subject to immigration's compliance and enforcement visit, I just wanting to say, obviously, you could have done your perfect right to work check and you still may have issues. For instance, like someone else, you could provide a statutory excuse if you have, if you really check someone else and that that right to work check is valid for 6 months, and somehow in between that 6 months someone else had their visa revoked, then obviously you have a statutory excuse. But if you are very, very unlucky, you encounter an immigration enforcement visit from the Home Office, do not panic, and obviously make sure when you as the employee or you as the employer are being interviewed, we come across this so often. The Home Office seems to think that there is, the transcript, well, they never provide us with the transcript. I just wanting to let you know, the transcript will never be provided during any of the stage of the illegal working inquiry stage, even after they handed down the penalty. If you ask them to disclose, they say that they will only disclose it if you go to the court. So if you go to the county court to oppose it, they will probably disclose it. But tell your employee, and if your employer, tell your employee, whenever you were being interviewed and they asked you to sign something at the end of the interview, please check the interview carefully. Because every time when I have someone else who come to me say, I did not read it, they just asked me to sign, I'm scared, so I'm just gonna sign it. No, don't. Read through them, because they can't force you to sign it. Read through them, take your time, ask them what does that mean if you are not fluent in English, what does that actually mean. Ask them to confirm with you before you signed it. Do not sign on any paper, do not sign on any white paper. If they ask you to sign something, if they ask you to sign on a blank paper, ask them, why do you want me to sign on this paper? I don't want to sign this paper. You do have your right as well. Don't panic when it comes to a situation like this. And if circumstances permit, you should try and take the photos and record as much evidence as possible, because they will be doing their own evidence. They always say to us, we have evidence showing that this person is a illegal worker, but they never actually disclose it. If at the initial stage well, if you don't oppose it to the point of where you go to court, they wouldn't disclose anything they have. So if you have any sort of like chances, try and record it, and maybe even consider putting a CCTV in your premises as well, just in case there is any kind of visit like this in the future. That would probably help quite a lot. And if you are an employer, well, actually not quite an employer, if you're an employee who has been so-called suspected of illegal working, or for instance, you may be someone else who's been waiting for an asylum's decisions. You didn't realize that your asylum decision has been cancelled, maybe because your lawyer didn't actually inform you. You didn't know that you have not got right to work anymore. If they do ask you to take any pictures, so I know some of the people who was a friend who go to a friend's place who does not have a legal status, they were somehow caught in this middle of the raid, and then the Home Office was adamant that he or she was working over there. And while they were taking the interview, once they finished the interview, they took pictures of the person. They asked them to go to the kitchen to actually take a picture, and then later on, well, obviously, I this is what my client has told me, so I can only say that, well, I think my client said to me that they were being asked to go to the kitchen and take a picture, and obviously the Home Office say that they encountered this person while working in the kitchen, and they have picture evidence of that. So obviously, who do we believe in this kind of situation? Then of course it's up to the county court to decide. Has the Home Office, is it probable, is it on the balance of probability, is that person actually was that person actually working in the kitchen? So if they do ask you to take a picture, try to find somewhere which is more neutral locations with neutral background, not like don't go to the kitchen and take it, if you see what I mean. If you've been encountered as an illegal worker in a restaurant, or in any kind of premises, to shows that you were actually working on that place, then obviously try and tell them that you prefer to take a picture here or there. You should always, tell them like what you do. They shouldn't really force you taking any pictures. If anything like that does happen, record that moment as well. Make sure you take a note on that. Okay. So what will happen then after the Home Office thinks that you were employing illegal worker? So the most common one that we deal with, obviously, was the information request. The civil penalty referral notice normally is like, for instance, like someone else who, like, the enforcement officers come to your premises, but the employer didn't allow them to do it, which I normally don't recommend. But if obviously you do that, they technically just handed you a referral notice, meaning that they will get you the information request form later on. The home office may make another visit as well. I do have a client who refused it initially, and then I think a couple of months later the enforcement team come back with a warrant. So I just wanted to let you know that that could potentially happen with information requests. Normally they do ask the employer to provide as much information as possible. This is your chance. If you do get information requests, please do not leave it to very last minute. A lot of my clients come to me very last minute. I'm not sure why, because the earlier we can respond to the home office, so it shows that we're cooperating, and they tend to reduce the fine later on as well. So information requests, if you do receive it, very important. Be quick, come to us, get us to help, if needed. Then the decision's outcome is normally when the home office will send you a decision. So if you are found liable, they will send you civil penalty. So it would just say a big red button in there, civil penalty notice, to tell you which workers, how much you've been charged for each of the workers, how you're going to pay, how you're going to object. And they normally have that statement of case, and if you have seen ones before, you know what I mean. They will say evidence shown that this person was working, blah blah blah. They will write it down. They wouldn't give you the evidence, they will write it down. They will tell you how they encountered. They will tell you about what you say and what you have done in the interview, and they will also say that you signed the interview transcript as well. So that's why I'm saying to you one more time, if you're employee or employer, make sure check the interview transcript before you sign anything, because you don't want any of this happening. Okay. The Home Office may only also issue a warning notice instead of a civil penalty notice, meaning that they suspected it, but they can't find anything. I so far have not had anybody else who come to me that has been given a warning notice, because to be fair, if they have a warning notice, they wouldn't come to us. Only when they get a civil penalty notice. Very rarely they will have that, because the Home Office normally only do a raid if they have a lot of tips from people, and they have been checking you out essentially. Then, of course, if you're found not liable for a civil penalty, then you get a no action notice, which means that the Home Office didn't manage to find anything. You are safe. So no action notice. Again, very rarely, but I have come across that with someone else with a right to rent check where the Home Office say no action notice. So that was a good one. Then how do you respond to it? So obviously, I wouldn't really go into much details on this, but basically the information request form, they will normally ask you to write down the details of your business, names of the directors, your registered name, your trading name, your address, your numbers, and etc. And they normally will ask you the suspected illegal worker will be named on it. They will ask you, when did you employ this person? Obviously, if you didn't employ this person, you would just say not applicable. Then you have to write it in your statement of case, and then you have to explain that. Then you will also have to confirm whether you've done your right to work check. So if you've done your right to work check properly, so this is the time for you to provide your evidence to them as well. So with the information request form, you're filled in, and when we do it, we tend to write a statement to the Home Office, and then we'll accompany them with all the supporting evidence as well. And in terms of what you should do is obviously seek legal advice. Is serious, because obviously nowadays is very expensive. If you do get fined liable for the penalty, is very expensive. You should seek legal advice ASAP if you actually receive an information request. And obviously you have to find out how whether the Home Office can actually establish that there has been an employer-employee relationship. And with that, obviously, the Home Office has a very wide interpretations, because after many years of dealing with them, I know the way how they do it. So you need to try to show, if you are not employer-employee, if this is not employee or that is not your employer, you will have to show that as an employer, they were not your employee, you're not paying them, and you're not giving them any benefit, like the one I was saying to you before. If they were doing voluntary work for you in exchange of something, they could actually consider that this is an employer-employee relationship. You should cooperate as soon as possible. Like I say, if you show that you are actively cooperating, it could be reduced by £5,000 per illegal worker. And of course, submit the evidence if you have done your right to work check. Again, right to work check, very important. So how do you deal with the penalty? So for instance, after the information request, if you will hand it down the penalty. Obviously, first thing first, if you are actually liable, like you did employ illegal worker and you failed to do your right to work checks, then of course, and you don't want to dispute anymore with the penalty because you don't have any stance on it, then of course you should try, if possible. In the past it is possible, because now I know that the price has gone up. It can have it reduced by 30% if you pay in full in 21 days. Obviously, if you're not capable of doing that, the other way of doing it is to set up the plan. So you can set up the payment plan. But if you do set up a payment plan, you are not qualified for the reduced penalty. So let's say if you were being fined £45,000, and then your reduced penalty by 30% would be about 31,000. But that only if you pay in full. So if you set up a payment plan for 24 months or 12 months, you will have to pay the full 45,000. Okay, then what will happen if you like to oppose the civil penalty notice? So if you do want to oppose, which normally, again, come to seek legal advice as well, because you will obviously, this is more like the information request is more like quite, well, I would say more casual. And then the civil penalty notice, when you oppose it, will be more serious. You'll be citing rules and everything like that. So I would highly recommend that you seek a legal advice on that. So normally with that kind of situations, you will have to raise the objections within a certain period of time. They will tell you normally on your letter, and obviously you will have to argue how you've carried out the check. You're not the employer, and then obviously there is other options as well, because there usually are grounds for you to oppose the penalty. One of them is like you're not the employer. Second of all, you have a statutory excuse. Third of all, you qualify for a reduced penalty, which is when there is a mitigating factors. For instance, you've been reporting the suspected illegal worker to the Home Office, or you've been cooperating. That's when they actually should be giving you a reduced amount. Then of course the Home Office will consider your objections. Then they will send you a notice whether they actually reduce the penalty, or they maintain the penalty as well. Okay. And finally, obviously, oh sorry, hang on. So finally, with the person, which after opposing, dealing with all the things, Home Office maintain the penalty, do not want to reduce, not gonna, do not want to change their decisions, then your final option is to appeal to the county court. And again, the appeal must be made within 28 days of the date specified in the notice. So the notice is very important. Make sure you check, speak to your legal advisor on that. And obviously the possible grounds of appeal is the same as the one that I mentioned to you just now about opposing it. So not the employer, you've done your right to work check, you qualified for a reduced penalty because the current civil penalty is too excessive. That's obviously the grounds that you could appeal on. And I just wanting to say, before you do take this road, be very, very mindful. Have you got all the evidence? Have you really, is this person really not the illegal worker? Did you really not employ this person? Because when it comes to a situation like this, if you do go to the courts can actually ask any kind of the losing party. So if you do lose when you go up to court, you have the legal fees of your legal advisor to pay, you have the barrister fee, you have the court fee, and you may be asked to pay the Home Office fee as well, because they were defending it, because you put in an appeal, that's why they have to defend it. So the county court can actually order the employer to actually pay for the Home Office fee. So this is normally not the ideal way, but if you are so adamant and you have all the evidence, then 100% go for it, but do seek legal advice on that. So last but not least, before I go, I know it's past the time. I just wanting to confirm if anybody else have any questions. I just checking on my colleagues over here. Any questions? Da, 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 da. No questions. So we don't have any questions. Just checking with my colleagues who are still on here, my marketing colleagues. No. Okay, so technically we have actually finished the webinar today. I'm gonna wait for another 2 minutes because I know we're past the time already. 2 minutes. But while waiting for that 2 minutes, of course, you can see that I'm stopping on this lovely signs of why you should subscribe, because this webinar today, if any of your friends you have employee, you have employer who is interested in understanding more about what happened with the new changes, and of course dealing with the dealing with the illegal working civil penalty. Feel free to share the webinar today with them, and of course follow us, because we do all this kind of great webinars every single now and then. So in order to get free information, you should follow us on all these platforms, our YouTube, our LinkedIn, Facebook, Instagram, X, no longer called Twitter, TikTok. If anything, you can obviously contact us on all these social media. They're all legit platforms, or you can ring us at our law firms, or you could actually contact us via email as well. There is so many different ways. We live in the 21st century. There is so many ways that you can actually contact us. So yes, absolutely anything, just let us know. And just to say, it's now 2 minutes past, and I don't think we still got any questions. I will probably say goodbye to most of you, because obviously yeah, it's past 15, is 15 minutes over the time. I just wanted to say thank you ever so much for joining us today. Thanks for joining Lisa's Laws at this webinar. I appreciate you guys taking your time to listen to this, and I do apologize for my voice is really bad at the moment, and I keep coughing about it. I keep coughing on it, but yeah, so thank you so much. Any questions, any things that I was rushing through earlier on today, drop me a message, drop me an email. If you want my contact details, you can speak to my colleagues as well, and they will be able to write it down. But I will actually, in fact, I will write in the right inside the sort of like webinar. This is my email address. If you do want to find out more about this, you could drop me a message at my email address, or you can actually ring us at this number, and you can just ask for Peggy. Thank you ever so much, everybody. I hope you all have a lovely weekend, because it's Happy Friday, isn't it? Okay. Thank you so much, everybody. I'll speak to you soon. Bye bye.